Good morning, everyone. Welcome to the next in the Serenity series, legal webinars that for intelligent entrepreneurs. And today we're going to be talking about Australian consumer law and its application to both Australia and New Zealand, and particularly in the context of entrepreneurs with a service-based business. So I'm going to share my screen now and we'll get started. Wonderful. Okay, I'm just going to put my little control thingy up here where I can reach it. And we go. So, as I said, Serenity series, legal webinars for intelligent entrepreneurs. And today we're talking about Australian consumer law, which is actually, as you'll see, applicable in New Zealand and even internationally as well. To start with, we'll have a little intro about me in case you haven't been to one of my webinars before. My name is Michelle Whitehead. I'm first and foremost a homeschooling mom, and this is the 8th webinar I've done in this series, and I haven't done one yet where a little person hasn't put in an appearance. So if that happens, please excuse me, and we'll just deal with the interruption as quickly as possible and move on from there. By profession, I'm a lawyer and I'm also a mediator. So my specialty is in small business needs, and particularly in heart-centered entrepreneurs who are looking for a business that is all about connection rather than competition. And I love reinventing the traditional legal constructs into a more feminine, more caring paradigm. Because I am also a heart-centered entrepreneur, and working with other people like you is what absolutely makes me sing. So let's see how understanding Australian consumer law can be really, really helpful for your business. What we're going to look at today is first the what. What is Australian consumer law? I'm going to do a quick broad overview of what it is and where it operates. Then we're going to look at why you need to know this. So we're going to look at the importance of consumer law in your business. And finally, we're going to get really, really practical and investigate how you can make sure your business is complying with the consumer law. And I'm going to say Australian consumer law because most of my clients are Australian. But if you are in New Zealand, then the Australian and the New Zealand consumer laws are almost identical. So pretty much all of this is going to apply to you as well. And there's reciprocal, as we'll find out, there's reciprocal enforcement arrangements. So basically, Australian consumer law can be enforced in New Zealand and vice versa. So what is Australian consumer law? The Australian consumer law replaces over 20 different consumer laws that originally varied between each state and territory. So the new nationwide consumer law provides a broad range of protection for Australian consumers. No matter where you are in Australia, you have the certainty of knowing that your purchases are protected under a single system. And you can sell throughout Australia and New Zealand knowing there is only one set of rules that you need to educate yourself about. Consumer law is the law that attempts to make sure we get a fair deal when we buy something, and which stops businesses engaging in fraud and other unconscionable practices to gain an unfair advantage over their competitors or to take advantage of a customer's vulnerability or weakness. For example, you might have rights under Australian consumer law if you've bought goods or services from a business based in Australia that didn't work properly, or broke very quickly, or was unsafe, or didn't function as expected. Most of us have had an experience like that where we've needed to go back and get a refund or a return or an exchange. But a lot of us don't consider how that actually works in relation to our own businesses and the goods and services we provide. The Australian consumer law also provides protection provisions relating to things like misleading and deceptive conduct, unconscionable conduct, unfair practices, unfair contract terms when dealing with standard form consumer contracts, consumer guarantees when purchasing certain goods and services, product safety, and enforcement powers and remedies. Now, a lot of those things might not mean much to you at this stage, but by the end of the webinar, I'm hoping you'll have a pretty good understanding of what unconscionable conduct or misleading and deceptive conduct means, how to deal with unfair contracts and how to stop yours being classed as unfair, and what your actual obligations are in respect of product safety, services that don't perform as expected, all that sort of stuff. So, why is this topic important? Australian consumer law is actually one of the most important laws for an entrepreneur to know about. Australia has very comprehensive consumer laws, and if you're selling your goods and services that, or buying goods and services from others, it's a really, really good idea to know what your rights and your obligations are. The Australian consumer law applies nationally to all Australian businesses, but the thing to remember is it's not punitive. That is, its main purpose is not to punish people who are doing things wrong. The real purpose of this legislation is to protect the consumer. So a consumer is anyone who purchases goods or services, whether you're buying from a manufacturer, a wholesaler, or a reseller. So if you're purchasing products to use in your business to on-sell, then you are still a consumer and you have rights against the person you're purchasing from, just as the people who purchase from you have rights. If you're selling goods or services in Australia, it's very important to be familiar with this law, as it can affect the enforceability of your contracts. It informs what needs to go into your policies and your procedures around customer complaints and your marketing practice and your advertising and promotional practices. Because there's basically that whole truth in advertising stuff that we're going to talk about as well. So as a small business or sole trader, I totally get that you don't have the budget for an in-house legal team to assess your marketing and your promotional material and ensure that none of your advertising can be considered misleading or deceptive. That's why I believe it's so important to supply this information to you so that you can educate yourself about Australian consumer law requirements and take your own steps to ensure compliance within this unique and beautiful structure of your own business. How am I going? Is everything good so far? Great. So, why? Ignorance is not bliss in this case. The fines for failing to comply with Australian consumer law requirements can be massive. And while you may think you're flying safely under the radar, it's no excuse to say that you didn't know about these laws when something goes wrong. So instead of worrying about that possibility, wouldn't it feel so much better to not only know exactly what the consumer law requires of you, and to know that you're fully compliant with it, and that you're providing your best practice services to your customers and clients? Knowing what's required of you puts you in a much better position to avoid the time and stress and financial cost of being fined or having litigation brought against you for a breach of these laws. When you're certain about what's required of you, you're also much more likely to be able to negotiate a better outcome when problems arise. It also puts you on guard and makes you a more informed consumer who's less likely to be taken advantage of through not knowing your rights. Finally, you're more likely to be able to recognise when other businesses in your industry are employing unfair tactics and to challenge their behaviour in a way that feels ethical to you. So, who must comply with Australian consumer law? Although it's a Commonwealth law, the Australian consumer law has been enacted into legislation by every Australian state and territory. This means it applies to anyone carrying on business in any Australian state or territory or in the Commonwealth. So that means it applies to government departments as well. The Australian Consumer Law is enforced and administered by the Australian Competition and Consumer Commission, the ACCC, alongside each state or territory's consumer agency. So in the ACT, New South Wales, Queensland and Tasmania, that's called the Office of Fair Trading. In the Northern Territory and Victoria, it's called Consumer Affairs. In Western Australia, it's called the Department of Commerce. And in South Australia, it's called Consumer and Business Services. But they're all basically the consumer agency for that state or territory government. And there's also the Australian Securities and Investments Commission, ASIC, which oversees any consumer law issues relating to the provision of financial services. So all of these bodies operate together under a memorandum of understanding that contains these broad commitments relating to communication, cooperation and coordination in administering and enforcing the Australian consumer law. And this memorandum of understanding between them also includes the New Zealand Ministry of Consumer Affairs and the New Zealand Commerce Commission. And this reflects the increasingly integrated nature of Australia and New Zealand's markets. So basically, there's a reciprocal enforcement of consumer laws, and there's quite an attempt on both sides to ensure that the laws are compatible and very, very similar. Okay, so it also has a very broad reach and can apply even to persons who ordinarily live or have a strong connection with the state or territory, even if they're not Australian citizens, and even if the behaviour occurs outside that state or territory or outside Australia. So technically, the provisions of the Australian Consumer Law apply to protect all transactions that occur in Australia. And as a point of law, this includes online transactions where the seller is international. So if you're an international selling into Australia, or if you're an Australian buying things from overseas, you should still be protected by Australian consumer law. The problem is you're going to face great difficulty in enforcing the Australian law against an international seller. So even if you went to court and successfully obtained a judgment of damages against them, in a worst case scenario, it's likely you wouldn't get much satisfaction from that, as there's no way to force them to pay up. Luckily, if you purchase through a reputable online platform such as eBay, or using a service provider such as PayPal or your credit card, then they have their own consumer protection provisions built in that can kind of claw back the money from overseas in a way that the Australian courts can't. So is that making sense? Let me know in the chat box if you've got any questions about that or if there's any problems. Now, it's not going to be possible to go into all of the complexities of how the Australian consumer law protects your rights as a consumer in the space of this webinar and still keep it under an hour. So what I'm going to do is just race through, and I'm going to focus mainly on the obligations of an entrepreneur who's selling services in Australia, because that is the majority of the people I work with. So let's take a look inside the consumer laws and see what's actually there. The first thing we're going to talk about is unfair contract terms. So as you know, if you've been following me for a while, a contract is an agreement made between two or more parties, two or more people, two or more entities, legal entities such as a corporation, that's intended to be legally enforceable. A consumer contract to which the Australian consumer law applies is any contract for the sale of goods or services, or the sale or grant of an interest in land to an individual for personal, domestic or household use or consumption. So these unfair contract term provisions apply to standard form consumer contracts. A standard form contract means one that is prepared by one party to the contract and then not negotiated between the parties. So it's basically offered on a take it or leave it basis. So we've all seen examples of these. Oh, good morning, Emma. I'll just mute you. Wonderful. Good morning, Emma. I'm just, we've done our introduction and we've talked about how the Australian consumer law also applies in relation to New Zealand and internationally. And we've just started to look inside the consumer laws to see what's actually there. And we're starting with unfair contract terms. So we've all seen examples of standard form contracts, as these are typically used for the supply of goods and services to consumers in many industries, including telecommunications. So when you sign up for a new mobile phone, you basically don't get any chance to negotiate the contract. You either sign up with that provider, accept their contract terms, or go somewhere else. Finance, so your bank fee, your bank terms and conditions, your mortgage terms and conditions, all of that sort of stuff. Domestic building contracts, if you're getting a house built, builders often use a standard form contract. Gyms, when you join up for a gym membership, when you're renting a motor vehicle, when you're traveling, and for your utilities like your electricity or gas. Now, a court can declare a term of a standard form consumer contract to be unfair. If a term is declared to be unfair, it becomes void. That means it's not operative. It has no effect and you don't need to comply with it. However, it's only that term, that unfair term, that gets cut out. The remainder of the contract continues to apply if it can continue without that void term. Now, individuals can apply to a court to have a term of a standard form contract they've entered into declared unfair and accordingly void, or the Australian consumer law regulators like the ACCC can also apply to have that declaration of unfairness. Oops, sorry, my mouse went off to the other screen. There we go. Next slide. So the law doesn't impose penalties on a business for including or seeking to rely on an unfair contract term, because as we saw at the start, the consumer law isn't punitive. It's not out there to punish people for doing it wrong. It's out there to protect the consumers, protect the people who are buying and selling, who are buying the services, sorry. So the consumer, however, you can seek compensation for any loss that's incurred as a result of a term of a standard form contract that's unfair. Now, the best way to avoid having your contracts labelled unfair, for example, if you've got a standard form contract, one that you've had drafted up, and you just put your new client's name in and adapt a few little bits to them, but you don't really give them, you just sort of hand it out to them, that's a standard form contract. And the best way to ensure that your contract terms aren't going to be labelled unfair and you're not going to have trouble with your clients is A, try to make sure that your contract is balanced. That means the rights and obligations that it creates are not all one-sided. So basically you get everything and your client has to do everything, or you're completely protected and your client has no protection at all. Just try and think about it from both points of view. How can you make this balanced and fair? B, try to make sure that your contract is written in transparent language that's easy to understand, so that your clients and consumers have a really good, clear idea of what they're getting into before they sign up. And that's why I use my worksheets and questionnaires for creating contracts, because when it really draws out your own language so that your contract is written and the elements you need to cover are covered in the way that you talk, in language that your people are going to understand. And then we go over them and over them to make sure everything is clear and consistent. Whereas if you're just grabbing a standard form contract or borrowing someone else's, there's a lot more chance that even you're not going to understand what's in your contract, let alone your clients. So it's a really good idea to to ensure if you are going to borrow a contract for someone else, or if you have got a contract that's drafted in traditional legal language, make sure you understand exactly what everything means, and make sure your clients can also understand it. The next thing is to treat each client as an individual. So don't have that one-size-fits-all approach. The thing I build into my contracts is a schedule at the back. So for anything that can change from client to client, like the scope of the work, the payment plans, all of that sort of stuff, it can be customized so that you're negotiating one-on-one with the client, treating them as an individual and customizing your contract to their individual needs rather than making it just a one-size-fits-all. And the last thing is to make sure you give them an opportunity to negotiate the contract. Now, this means coming back to them after you've sent out your contract and asking them, checking in, is there anything in this contract that you don't understand? Is there anything in here that you're not comfortable with? Is there anything in here that you feel is unfair? And address their concerns in whatever way works for your business. And it's so much better to get this stuff sorted out and to make sure that you're all on the same page at the contract formation stage, rather than waiting for your client or customer to get unhappy and start to complain to the ACCC or the courts or wherever else they're going to go, or even just to resist fulfilling their obligations like paying you. So, consumer guarantees. Moving on to the next topic. We're done with contracts. Consumer guarantees. This is a big one, really important. It affects what can and can't go into your refund policy. So, a consumer of services is a person who buys, under the Australian consumer law, it's a specific definition. So a consumer of services is someone who buys any type of service costing up to $40,000. And that amount can even change by the Australian consumer law in the future. So at the moment it's $40,000. Or services costing more than $40,000 if they're normally used for personal, domestic or household purposes. Another thing to remember is that people who receive these services as a gift have the same rights and responsibilities and are entitled to the same remedies as consumers who buy the services directly. So if someone buys your service and gifts it to someone else, the recipient of the gift can also enforce these consumer guarantees against them. They're entitled to rely on these consumer guarantees. Now, these rights exist regardless of any warranty or exclusion of liability provided by the supplier or the manufacturer. So it doesn't matter if you say in your contract that, that there is no returns or strictly no refunds, because these guarantees apply automatically. So Emma's got a question. If you ask your client, are you happy with the contract? Is there anything you don't agree with, etc.? Aren't you just opening up an unnecessary dialogue, opening a can of worms? Some people like to be contrary, and given the chance, we'll nitpick. What are your thoughts? Well, in that case, it comes down to your risk appetite, your risk tolerance. It's a balancing act for you to decide which is more important to you, to risk your client being unhappy with the contract by handing them a standard package that they have no opportunity to negotiate and to express any concerns about, or to even clarify any misunderstandings with, or whether you would prefer to invest the time in increasing the communication between you and your client. So it's really a trade-off there, based on what you know about your clients, how you feel about your communication levels with them. If you think that they're just the nitpicking type, and that you just want to have that standard contract there, then that may be the way that you go, but then you have to understand that you're taking the risk. It may just be a tiny risk, but you have to assess that in the context of your own business by basically looking at the other elements of that. Is your contract balanced? Is it fair to both sides? Is it sort of, have you taken into account the individual customer's needs? All of that sort of stuff that could then reduce the risk of you having an unfair contract claim made against you. And there's also the thing to remember is that it's only the unfair term. So they would have to go to court. They would have to claim that the contractual term was unfair. They would have to prove their case that it was unfair. And it would only be that term that was cut out of the contract and declared void. The rest of the contract would still continue. So in that situation, you might decide that that's a risk I'm perfectly happy to take. And I would rather just hand them the contract and say it's a take it or leave it contract rather than allowing them to nitpick. And in fact, that's what the electricity providers, the mobile phone providers, what all these big providers do. Because they're not going to individually negotiate with each of their millions of consumers that are buying from them. Does that make sense? Does that answer your question? Yeah, okay. So, back to consumer guarantees. For the purposes of this webinar, I am just going to focus on suppliers of services when talking about consumer guarantees. If you want to know more about consumer guarantees applying to manufacturers or suppliers of goods, ask any questions in the chat, or I can share some great resources with you after the webinar. So we're already halfway through, so I'm going to have to race, which is why I can't cover everything. I wish I could. So suppliers of services. Suppliers guarantee that their services are provided with due care and skill. This means they must use an acceptable level of skill or technical knowledge when providing the services and take all necessary care to avoid loss or damage to their customers when providing those services. Suppliers also guarantee automatically that their services will be reasonably fit for any purpose specified by the consumer, and that any products resulting from the services are also fit for that purpose. So with Emma Vega Malta, for example, the services she provides would be, for example, backdrop design, and the product that she produces, the products resulting from that service, would be the actual backdrop. Now, mine isn't designed by Emma, but my beautiful logo certainly is. And so Emma would be automatically guaranteeing that her backdrops are fit for the purpose for which her clients intend to use them. Now, suppliers also guarantee that their services and any resulting products are of a standard expected to achieve the desired results that the consumer made known to the supplier. So if your customer tells you that they want your services for a particular reason, you can't just sort of bury that that niggling feeling that tells you, oh, I'm not quite sure if my services will do that. You have to talk to them and let them know that that there may be a problem, because you have this guarantee that they will be of the standard expected to achieve those desired results if those results have been made known to you. So a contract or agreement for the supply of services usually states when the services will be provided and the date they'll be completed. If it doesn't, the Australian consumer law, consumer guarantees that those services will be supplied within a reasonable time. Now, what's reasonable is going to be dependent on the nature of the services, but there is that guarantee in there that services will be provided in a reasonable time. Now, in general, services are covered by consumer guarantees when they are sold in trade and commerce and bought by a consumer. So in trade or commerce, means in the course of the supplier's business or professional activity. And that includes a non-profit business or activity. So if you are doing, for example, for me, pro bono legal services, helping someone out without asking for payment, if you are gifting your work for any reason, these consumer guarantees still apply. If you're engaging in a skills swap, all of these things, these consumer guarantees are still there. The person who is in receipt of your services still has the result, still has the right to expect these things. Okay, so next. Major failure of service. So consumer guarantees basically come down to two things: a major failure of service and a minor failure of service. Talking about major failure of service, a major failure with services occurs when a reasonable consumer would not have acquired the services if they had known the nature and the extent of the problem. For example, a reasonable consumer would not pay to have a backdrop designed, using Emma again. Sorry to use you as my guinea pig today, Emma, but you're perfect for this as an example. They wouldn't pay to have a backdrop designed if they knew that backdrop was going to fade within a week. Emma's quite happy with me using her as an example, so that's great. If the services are substantially unfit for their normal purpose and cannot easily be made fit for such a purpose within a reasonable time. For example, imagine a carpet cleaning service which changes the colour of the consumer's carpet in some places. That would be a service that's substantially unfit. Or, and this is what we just discussed before, if the consumer told the supplier they wanted a specific result, but the services and any resulting product don't achieve that result, and the service can't easily and within a reasonable time be made to achieve the result. Hang on a sec. Marie, you've got milk in your iPad in bed. Go play there, please. I'm recording a video. Okay, pause. I can't stop. So, for example, if a consumer asks a technician to increase the memory capacity of their computer within 1 week, and they say that they need this to be done because they've got an important presentation coming up. And then while installing the extra drive, the technician damages their existing hard drive. And repairs are going to take 6 weeks, but the consumer needs the computer within a week, and they told the technician they needed the consumer within that time. And basically, it can't be done. So that's another situation where there's a major failure of service. And finally, where the supply of the service creates an unsafe situation. For example, where an electrician incorrectly wires wall sockets in a consumer's new kitchen and makes the electrical outlets unsafe. Marie, please. I'll be with you soon, but right now I'm recording a video and you need to go away for a minute, okay? Thank you. Sorry, everyone. As I said, interruptions occur. So what do we do when there is a major failure of service? And you're going to need to think about this in the context of your own business. Have a look at what it is you provide in relation to each of these 4 types of major service, and think about what that could look like for you. In what circumstances would a reasonable consumer not have acquired the services if they'd known about this problem? How could your services be unfit for the purpose? Watch out for when your customers and clients tell you they need a specific result. Make sure that your services can achieve that result before agreeing to provide them. And finally, look at all the ways in which your supply of services might create an unsafe situation. And that's particularly important for health service providers or for allied health service providers, as you know, and that's where disclaimers come in. So what can you do where there's a major supply of services? The consumer has the right to either cancel the services and get a refund for any parts of the service that have not already been consumed, so any parts they haven't used, or keep the contract on foot and be compensated for any difference in value between what they expected to get and what they actually got. So you might have to pay them that difference. Where there's a major failure, the consumer can also take action to recover damages from the supplier for any reasonably foreseeable damage or loss. So they can look for damages from you for stuff that could reasonably have been prevented if you had taken this stuff into account in the first place. So, however, a consumer is not entitled to a remedy if the supplier failed to meet one of these consumer guarantees due to something that someone else said or did. So, for example, if your secretary or an employee promised something that you couldn't deliver, and it's not your fault because it's a third party, or if the thing that caused the major problem is beyond human control and it happened after the services were supplied. So, for example, if I bought one of Emma's beautiful backdrops and there was a fire in my house and my backdrop burnt down, then I could not say to Emma that my backdrop was unfit for its purpose, because that would be something beyond her control and it happened after she supplied the services to me. Now, a minor problem. A minor problem is a problem with a service that can be fixed. And in that case, the consumer cannot cancel and demand a refund immediately. The consumer must give the supplier who provided the services an opportunity to fix the problem, free of charge and within a reasonable time. And once again, reasonable depends on the circumstances. Now, if a supplier refuses to fix the problem or it takes too long for them to fix it, the consumer can take it to someone else and get them to fix the problem or deliver the services and then recover the reasonable costs of doing so from the supplier. So it's in your interest to work with people who have a complaint about a minor problem, because if you refuse to help them, they have the right to go and get that service provided by someone else and make you pay for it. They can also cancel the contract and get some or all of their money back if they've already paid. And a consumer who is not yet paid or only partially paid can refuse to pay for the defective services at all or pay less than the agreed price. And once again, this relates back to the actual consumer guarantees that they'll be supplied with that there'll be an acceptable level of skill and technical knowledge, that they'll be reasonably fit for their purpose. So examples of a minor problem are things like someone getting sick and not being able to make an appointment, technological failure during the middle of a meeting, that sort of stuff. Little things, all the little things that can go wrong. And it's really just a case of brainstorming what are all the little things that could go wrong when I provide my services. And what am I going to do about it to make it right for the consumer? Because it's not their fault. Things go wrong. We both understand that. We just do not have the right under consumer law to put a blanket denial on not fixing it. So that brings us to our refund policy. And this is where we tell our consumers, our customers and our clients what we're going to do if one of these things happens, so they know upfront what to expect. So what your refund policy cannot say. A refund policy cannot limit or seem to limit the consumer's rights. This is unlawful under Australian consumer law. And this includes displaying a strictly no refund sign. So, but you've seen people do it, and they get away with it because other consumers don't know their rights. But suppliers cannot modify, restrict, or exclude the consumer guarantees, or avoid their obligations by getting the consumer to agree that the law of another country applies to their contract or dispute. So even when someone's overseas, they can try and say that their consumer law applies to your agreement, and so they have no right, you have no rights under Australian consumer law, but this isn't the truth. Australian consumer law still applies, although, as we said, there's that problem with enforceability. A supplier must not tell a consumer that they're required to pay for any rights equivalent to a consumer guarantee. So this means things like when selling an extended warranty, a supplier or a manufacturer should be very clear exactly what it offers over and above these automatic consumer guarantees that everyone is entitled to. Consumers cannot sign away their consumer guarantee rights. If a supplier attempts to put terms in their contracts that are a complete avoidance of any responsibility, they may also be misleading the consumer about their legal rights to compensation for consequential loss. And these terms could then be considered unfair contract terms. So suppliers must be very careful about what they say to consumers and the wording of their signs, their advertisements, or their any other documents. You cannot tell a consumer that a consumer guarantee doesn't exist, may be excluded, or may not have a particular effect. Now, the maximum civil penalty for providing false or misleading information about the existence, exclusion, or effect of a consumer guarantee or their remedies available to them is $1.1 million for a company and $220,000 for an individual. And criminal penalties for the same amounts may also be imposed. So you may end up with a criminal record as well if you ignore this stuff. Signs that state no refunds are unlawful because they imply it is not possible to get a refund under any circumstances, even when there is a major problem with the goods. For the same reason, the following signs are also unlawful. No refund on sale items. It's still a refund. Your consumer guarantees still apply. Exchange your credit note only for return of sale items. If it's a major problem, you have the right to make them fix it in some other way. However, a sign that states no refunds will be given if you have simply changed your mind is acceptable. You don't have to give a refund for change of mind because that is not a minor or a major problem with your services. A supplier does not have to give a refund when the consumer simply changes their mind. However, a supplier can decide to have a policy where they offer a refund or a credit note if the consumer decides they don't actually want those services after all. And this is a personal decision to make based on your own customer relations and your own customer experience that you want to create. I keep talking about the example of one of the business coaches whose email script list I'm on, and he regularly offers his products and his services with a $100 money back guarantee. So not only do you get your money back, he pays you an extra $100 US on top just to thank you for trying out his services if you're not happy with them. So it's really individual based. The whole change of mind refund thing is really individual based on the customer experience you want to create. Now, a good refund policy sets out what your refund for change of mind policy is. Whatever it is you come up with, it tells people about it. It describes the types of major problems that occur and the options available, how you intend to handle those major problems, those foreseeable problems. It describes the types of minor problem that occur. So the results of all that brainstorming goes in your refund policy, where you tell people, this is what could go wrong, and here's what I'm going to do about it if it does. So there's no uncertainty, there's no, oh dear, how do I go and apply my consumer guarantee, my consumer rights, because you've already set it out for them. This is what happens. And it will describe your requirements. For example, if a product is damaged in the post, you might want them to provide photographs of the damage. If you've got lots of clients and you're providing a service to a lot of clients, you might want them to come back and provide you with proof of their purchase, so the receipt that you gave them. Whatever it is that you need them to provide you with as evidence that a major problem or a minor problem has occurred, that needs to be in your refund policy as well. If you cover those things, you don't really have to worry about the uncertainty of the consumer guarantees or those huge fines, because you've got it covered. You've already worked out what you're going to do to manage these risks. Okay, so that's consumer guarantees. How's that? Is everyone pretty good with that? Is there any questions about consumer guarantees? I'm going to jump on now to truth in advertising. Okay, so truth in advertising. We're going to look at this rule very briefly because we're getting out of time. I'm going to go over a bit over, I think. Unfortunately, I'm sorry about that. You're welcome to jump out if you need to, and the replay will come out. But as you can see, there's so much to unpack here, and it's so important to understand. Okay, so under Australian consumer law, truth in advertising can relate to misleading and deceptive conduct, unconscionable conduct, false and misleading representations, and a failure to disclose relevant information. So it's unlawful for a business to make statements in trade or commerce that are misleading or deceptive, or are likely to mislead or deceive. Failing to disclose relevant information, promises, opinions, and predictions can also be misleading or deceptive. And in most cases, businesses can't rely on their small print and their disclaimers as an excuse for misleading or deceptive conduct. So for example, if Emma told all her clients that buying one of her backdrops would make them look like a movie star on camera, and she did it in such a way that, you know, they would believe her, then that would be misleading and deceptive. If I told all of my clients that getting a contract drafted by me would be watertight and would protect them in all circumstances, no matter what, that would be misleading and deceptive, because I do not have a crystal ball that works really well, and I cannot tell what's going to happen down the future. All we can do is do our best to protect you at the point in time when we're creating your contract. And so it's not a matter of disclaimers and small print, it's being honest with people. Emma says, I'll look like Audrey Hepburn, guaranteed. I'm in, Emma. Expect my order tomorrow. As long as I get this finished, she is too. Okay, so we need to look at how the behaviour of the business affects the consumer's impression of the goods or services being offered. What are you leading them to believe about what your services can do for them? So, when deciding if conduct is misleading or deceptive, the important thing to ask is whether that overall impression created by the conduct is false or inaccurate. And so even if a consumer discovers the true position before the conclusion of the transaction, the business may still contravene the Australian consumer law if the consumer has been what they called enticed into the marketing web by the misleading conduct. So it's always better to be realistic, upfront, honest, authentic about what your services do. Now, one exception to this is the common advertising tactic known as puffery. Now, puffery is not considered misleading or deceptive conduct because it relates to wildly exaggerated, fanciful, or vague claims that no reasonable person could possibly treat seriously or find misleading. So, for example, if Emma did tell me that her standing in front of her backdrop would suddenly transform me into Audrey Hepburn, then that would pretty much be puffery because no one's going to take it seriously. So there's that line. There's exaggeration for effect, but then there's what's misleading and deceptive. And it hinges on the consumer's belief, what they're actually going to believe. So on the other hand, even silence can be misleading or deceptive when you fail to disclose something that only you know and that is relevant to their decision making. So for example, if you know that, say Emma knows that her backdrops will only look perfect if the customer has a professional lighting setup, and she sells her backdrops to people without telling them, hey, you're also going to need to purchase professional lighting, that would be a misleading silence. So if you fail to convey important details, or if the circumstances have changed since the information was provided. So for example, if I told everybody, yes, your contract protects you, but then there's a change in the law before the transaction's finished, and I don't tell them, hey, look, the law's changed, we're going to need to go back to the drawing board and redo this contract, redo this refund policy because they've changed the Australian consumer law. That my silence on that could also be misleading and deceptive. Whether it is misleading or deceptive is always going to depend on the circumstances. There's no one-size-fits-all answer here. It's always going to be what specifically happened in this case. So it's recommended that businesses prominently display all disclaimers and any terms and conditions that apply to an offer in close proximity to the headline statement to reduce the risk of their conduct being misleading. So if you've got a disclaimer that says, I'm a lawyer, I don't provide financial advice, I'm a massage therapist, it's not a substitute for counselling, medical treatment, all the rest of it, you've got to make it obvious. You can't hide it away in a little tiny spot somewhere. You need to provide it to your clients in their welcome pack. You need to make sure they get it or get the message. It's unlawful for a business to make false or misleading representations about goods or services when they're supplying, offering to supply, or promoting those goods or services. For example, you can't make false or misleading representations about the standard, quality, value, or grade of your goods and services, the composition, style, model, or previous history of use of goods, whether the goods are new or not, whether a particular person has agreed to acquire the goods or services. So, for example, if a real estate agent says, you've got to really hurry up and buy this property because we've got another buyer who's ready to go now, and they have no other buyer, that would be misleading and deceptive. Testimonials by any person relating to goods or services. Your testimonials must be true. You can't just make them up. That would be misleading or deceptive. Sponsorship, approval, performance characteristics, accessories, benefits, and uses of goods or services, their price. You can't, full scarcity, absolutely. I bet that does happen a lot. And it's misleading and deceptive. And if you catch someone out about it, you can report to them to the ACCC if it's really important to you, if it's something that is, for example, it helps you understand how your competitors may be not behaving ethically. the price of the goods or services. So when someone says the price of the services is this, and then they don't tell you that it's plus GST, or they don't tell you actually it's in American dollars, not Australian dollars, that can be misleading and deceptive. That can give you your consumers a right to come back at you. The availability of repair facilities or spare parts, the place of origin of a product, where it's being made or assembled. A buyer's need for the goods or services, you can't tell them, you must have, I can't say to everybody, you must have a contract or else you'll get in huge trouble. It's not like that. It's just, these are highly recommended, they reduce your risk, you explain the reality of the situation to them rather than doing that whole fear selling the stuff. Any requirement to pay for guarantees, warranties, or conditions of the goods or services, it's all there. So, yeah, a representation can be misleading, even if it's true or partly true. It depends on the circumstances. It's always going to depend on the circumstances. So you have to be as honest as possible, and you have to make that honesty obvious. So that's false and misleading. Any questions there? And if not, I'm going to move right on to unconscionable conduct, which does lead pretty well on from false and misleading representations. So generally, unconscionable conduct is conduct that defies good conscience within the context of society's norms and expectations. For conduct to be unconscionable, it needs to be more than merely unfair or unreasonable. A business cannot act unconscionably when supplying goods or services to a consumer or when acquiring goods or services from a consumer or business. And the prohibition against unconscionable conduct under Section 21 of the Australian Consumer Law extends to a broader range of conduct than what the unwritten law, the common law, has traditionally considered to be unconscionable. So unconscionable conduct is harsh, shocking, grossly unfair, oppressive, stuff that's beyond what you would consider normal behaviour for our society. Stuff that is excessively unreasonable. So the Australian Consumer Law sets out a number of matters that a court can take into consideration when determining whether conduct in connection with the supply of goods or services is unconscionable. And these factors include the relative strengths of the bargaining power, the bargaining positions of the supplier and the consumer, whether the customer was required to comply with conditions that were not reasonably necessary for protecting the legitimate interests of the supplier, whether the customer was able to understand any documents relating to the supply or possible supply of goods or services. Whether, and this is customer by customer. So for example, a lot of banks have gotten into trouble because they've, for example, there was a recent one where a bank convinced an 80-year-old woman to take out a 30-year loan. And her ability to understand the effect of the transaction she was entering into was obviously compromised. And yet, so this is where the consumer protection comes in. It's not happening so much at the base level of entrepreneurs providing services, but it still applies to us, and that's why we need to know about it. And we also need to know it for protecting ourselves when we're buying goods and services from others. So, undue influence, pressure, or unfair tactics. We've all seen those being used, and many of us have been at the receiving end. I've had a coach who I felt put undue pressure and used unfair tactics on me in an attempt to convince me to buy her services. And luckily, I'm stubborn enough that I basically decided that I was going to prove I could do it without her. But there was definitely a moment there where I was convinced that I would never succeed in my business if I did not pay her the huge amount of money she was asking. The amount for which and the circumstances under which identical or equivalent goods or services could have been acquired from someone else. So basically looking at your market value, or how are your goods and services placed in the market value, placed in relation to the market. So if you're offering something at a huge discount, you're less likely to have consumer stuff enforced against you because it's obvious that you're providing the customer with a greater benefit. Similarly, if your services are extremely highly priced and you're using undue influence and misleading or deceptive advertising, then you're more likely to get into trouble with the Australian consumer law. It's common sense. Okay, the extent to which the supplier's conduct with the customer was consistent with the supplier's conduct in similar transactions between the supplier and similar customers. So, for example, if you've got a client who you decide is being a bit of a pain in the ass and you decide to raise their prices and charge them extra fees just because they're annoying you, they could come back and say, hey, look, this is not consistent. This is unconscionable conduct. How dare she treat me differently from all of her other clients? She's not charging them these extra fees, it's just me. And finally, the extent to which the supplier and the customer acted in good faith. So if the customer's lying to you and you're lying to the customer, neither of you have got a leg to stand on. This is the simple answer. If you're lying to the customer and they're believing everything you say and accepting it as gospel truth, then you're the one going to be in trouble. If you're telling the customer everything upfront and honest, and the customer is nitpicking and lying and trying to get around you, pull a shifty on you, then their behaviour is unconscionable. It works both ways, cuts both ways. Basically, it comes down to looking at your own conduct and thinking about what reputation you want to have as a business, and then making sure your conduct is in line with that desired reputation. So, examples of unconscionable conduct by a business may, depending on the circumstances, include not properly explaining your contract conditions to someone that you know doesn't speak English or has a learning disability. They just don't get it. You know that they just don't get it. You've got to take the time to explain it to them in a way that they do get it. Signing person up for a training course that you know they've got no means of completing as they don't speak English or they've got a disability. That's a big one. Not allowing them sufficient time to read the agreement, ask questions, get advice, consider whether it's a good agreement for them. You've got to give them time to consider the contract and whether it's right for them before you get them to sign it. Using a friend or relative of the customer to influence their decision. Inducing a person to sign a blank or one-sided contract. Have you ever been asked to sign a contract where there's whole stuff of it blank and the person says, oh, don't worry about that, I'll fill it in later? That's unconscionable conduct. It can also be unconscionable if you make them sign a contract where everything is on your side and nothing is on theirs. So it's completely unfair to them. They're not getting anything out of the deal. Taking advantage of a low-income cost consumer by making false statements about the real cost of a loan. That's one specifically for the financial industry, but think about how it could relate to you. You know, sucking people in, saying, oh, look, it's a real deal. It's normally this huge price and I'm offering it to you for only this price. When you know that that's still more than they can really afford. Failing to disclose your key contractual terms. Make it obvious to them. Put this stuff out there for them. Using high pressure tactics, such as refusing to take no for an answer. Sustaining a sales pitch for a long period of time. If you've been caught on the phone with someone, I hang up on them. But for someone who just keeps talking and talking and talking and talking and talking at you, like I'm doing now, and if I was selling, you know, some of these webinars that are just a sales pitch, if you're locked in there and you couldn't leave, that would be unconscionable conduct. Similarly, refusing to leave someone's home. If you're a door-to-door salesperson and you refuse to leave their home, that's unconscionable conduct. And as always, whether particular conduct is unconscionable will depend on the particular circumstances involved. That's all dependent on the individual circumstances. So we've done pretty well. It's only 5 minutes late, so yay us. We've stuck to nearly an hour. Ground your castle in the air. I'm always on about this. Do you still think Australian consumer law is confusing or irrelevant? If so, ask me questions. Work out how this stuff relates to your business, because it's so important as one of these solid foundations for getting your business grounded, for making sure that it's safe. Okay. And also it's really cementing your customer experience. All of this stuff I've talked about. Don't approach it from fear. Don't approach it from, oh, the ACCC is going to come after me. I could be fined $220,000. This is terrible. Think about it from your customer's experience. How can I make my refund policy serve my customer better? How can I make my and my business better? You know, it's self-care for your business and it's care for your customer. How can me being truthful in my advertising look after my customer better? How can me understanding what unconscionable conduct is and making a commitment to my business that I will never engage in unconscionable conduct, how can that serve my customer? How can that be of benefit to my customer and my business? Because one customer well taken care of could be more valuable than $10,000 worth of advertising. So you are benefiting your business by taking care of your customers. That is an absolute core fact that I believe in 100%. Final tips. Know your rights and obligations. The Australian consumer law applies to you and me. Create fair and balanced contracts and consider whether you want to give your clients an opportunity to negotiate around them, or whether you are consciously accepting the risk of using a standard form contract. And if so, go back and make sure, absolutely certain, they are fair and balanced. Have a good, well thought out refund policy that's easily available at your point of sale. Avoid exaggeration and extravagant advertising, unless you're being so far out that everyone just gets that you're being silly. And if there's any questions, make it obvious. And finally, treat your clients and customers with respect. If you're treating everybody with respect, then there's no, unconscionable conduct is never going to be an issue for you. And here comes the second of the quotes that I think is absolute truth. Your clients are never going to care how much you know and how good your services are until they know how much you care about them. And caring about your customers and your clients is absolutely the most important step in grounding your business and having a successful business. So if you'd like to find out more, you're very welcome to join my Business Serenity Facebook group. You're welcome, you get the answers to all your business legal questions there. We've got an Ask Away hashtag where you can ask questions any day and I will jump on and answer them. And we're getting a lot more people there who can also answer questions for you. You can also get entertaining and informative discussions about consumer law, contracts, risk management, intellectual property, and all of your entrepreneurial legal needs. The group is easy to find. It's facebook.com/groups/business.serenity. And if you have any questions that you would like me to talk about with you one-on-one, you can book in for a free 30-minute consultation. And as you can see, I can pack a lot of information into 30 minutes. And you can just book it there at mmw_consult. There's a little underscore there that you probably can't see because of the underlining. And I'll put that in the chat box. Actually, you guys already know how to get in contact with me. And that's it. I'll stop sharing my screen. Phew, that was quite a marathon. Thank you so much for joining me. If you're watching the recording, I hope you also get a lot out of this. Emma says it was brilliant, which is wonderful. I'm so glad it's useful for you, Emma. And I'm so glad you came on so I could use you for an example, because your products and services really do provide wonderful illustrations. But anyone's do, really. I couldn't think as quickly on the fly about teeth. Sorry, Melios. But yeah, you can really think the same way. No matter what your business is, this stuff is applicable to you. And it really is important to understand it. So let me know if you have any questions, and I will catch you next month, where we will be talking about contracts, client service agreements next month. For April, our webinar will be on client service agreements and contracts, and how to make sure your contract is lovely and fair and balanced. Okay, talk to you soon. Bye, everyone.